Today was one of the days where, as a litigation lawyer, you have to argue on question of fact. I filed a child custody matter at the family courts of Secunderabad, and there was an objection raised with regards to the ordinarily residence of the minor wards. There is a general practice or a straitjacket formula. The jurisdiction of the courts where the minor resides, that is where you have to file the custody petition. However, I appeared today and argued the matter on question of fact, placing a lot of citations and also the provisions of Guardian Wards Act, wherein I mentioned that the definition of ordinary residence is a wider definition and no straitjacket formula should be applied while entertaining the application of child custody matters. I defined the proper definition of ordinary as well as the residence part, and it says clearly that it is the part where you dwell permanently, where you have cohabited for a longer period of time, is what an ordinary residence or ordinarily residing means. Section 9 of Guardian Wards Act defines the territorial jurisdiction of the courts, wherein I also argued that the ordinary residence is the place where the parties have cohabited along with the child and not the place where they have temporarily moved or shifted. And the same case happened today in my case, wherein there was a dispute between the parties and one of the parties took away the child. And here in this case, if one of the parties takes away to America, you cannot run pillar to post to get the child custody or visitation rights to America. The courts need to apply its wide discretion and decide the cases on case-to-case circumstances of the facts on that basis. And it was very well heard by the Honorable Judge, and it was considered that ordinary residence means the place where the parties have cohabited for a longer period, where the residence is usually a permanent residence of the parties. This will help a lot of lawyers and litigation lawyers who are filing child custody matters to use these provisions in question of fact to ensure that the child custody petitions are filed in the jurisdiction where they have last cohabited for longer period, where their permanent abode is there. That is where you can also file a child custody matter, and not the place where they have temporarily shifted on a coercion or on by force. You can very well file at the place where they have cohabited for longer duration, and that is what happened today. And I'm very happy that the Honorable Judge heard me patiently and allowed the petition to be numbered and to be heard.